G'day everybody! How's it going this week? Well, if you're a furry YouTuber, it's probably not going too well. A recent thing has been going around YouTube, and probably most of you have already heard it at this point. If I'm the first person you're hearing it from, then I'm very flattered because you probably don't watch much YouTube other than my channel. And given that I don't have many subscribers, that's very nice of you, and that's very kind of you. But the reason that furries are very concerned is over a recent issue that has occurred on YouTube dealing with COPPA. And that thing broke again, so if you want to Patreon support me, link in the description below. I need to figure out how to do that better, because that's not working anymore. If any of you know how to make a good marquee thing or any random tool, please leave a comment. Basically, I was just using like a marquee and on a random website, and it only can go a certain length, it seems, before it cops out, which isn't going to be helpful if I get more YouTube subscribers. I'm trying not to draw attention to the Patreon thing, but it decided to draw attention to itself. Okay, whatever. Let's get to the actual news. So, other than my incompetence. So, this particular issue that has hit YouTube is a very serious issue. It's a very it is the government coming down on the internets, using a older law, which had a reform in 2013. The original law was written in 1999. It was updated in 2013, and apparently they have finally done it. They finally really did it. Those maniacs! They blew it up. All right, so no, it's a serious topic. Okay, I'm trying to make light of it, but it does impact a lot of people, particularly individuals who have channels that gear towards the more youthful at heart. And because furries do that, it is an issue there. So what happened is that back in September, Google and YouTube and everything had to make a settlement with the FTC. The settlement was over a particular issue, and that particular issue was of failing to meet COPPA guidelines and compliance. So what is COPPA or COPPA? C-O-P-P-A. C-O-P-P-A, C-O-P-P-A, C-O-P-P-A. You're not going to catch me, COPPA. But the COPPA did catch him, unfortunately. So what is that? So that's the Child Online Privacy Protection Act. Most of you might not know what that is. The quickest way I can kind of describe it is, do you remember back in the day when you heard those, ask your parents' permission to go online? And when you watch those Saturday morning cartoons and they would make advertisements for something like Neopets. You remember Neopets? Not many people do. I remember Neopets. My coloration's based on a Doresian Afra. That's why I got spots on the back of my ears that turn around. See? See? That's where those come from. I don't know if you saw them or not. I can't see behind my head. I don't have eyes in the back of my head, but I have spots. And that's where those spots came from. I really like Doresian Afras. I'm a kangaroo guy. I like that. So, the reason that they would tell you to ask your parents' permission to go before going online is because of COPPA compliance. What COPPA compliance is that sites that are directed towards children were seen as a risky venture, because if an individual, anyone can create any website anywhere. Welcome to the internet. So if a creepy creeper out there, right, wanted to make a child-directed website, let's say that this happens, right, and it probably did happen a few times, and that's why we have our COPPA regulations. Let's say some creepy creeper out there wants to get some dirt on some kids, you know, creepy men like that, you know. What they could have done is they could create this website, right? And they could have the kid put in all this information, their home address, their phone number, their name, and all that information would be given to their company. And, you know, people in that company, there could be creepers in that company, you don't know. So a lot of parents were very paranoid. This internet is a brand new thing. It's a whole new world, interconnected. it's the first time that strangers can enter your home through this magical box in front of you. And so a lot of people were concerned about, protecting children from naively giving out their information to strangers on the internet, which they can use to, kidnap them, harm them, do harm, figure out them, and be generally creepy. So that's what COPPA was designed for. It was designed so that the only way that that a child could give information to a website was through their parents' permission. And it was really, and it's supposed to empower the parents to say, yes, I allow you to go to this website. No, I don't allow you to go to this website. It's supposed to empower parents in order to do that. That's how it was in 1999. In 2013, so the law, if you read it, you did read it, did you? I read it. I read a little bit of it, and that's the fun part. Because when you read stuff, you find out stuff, and you can have some fun with it. We're going to have some fun with it later on, but let's go over the background a little bit first. So in 2013, they updated it a little bit. So in 2013, they updated the law a little bit so that basically that, because it's a Web 2.0 world. Back in 1999, it was a Web 1.0 world. And what a Web 1.0 world means is, picture it, a Wikipedia page that you can't edit. Yes, yes, yes. It's scary, isn't it? But that's the internet I grew up with. You go to websites, you click on links, and you can read stuff. That's all you could do. You can't interact with anything. You can't make videos. You can't put on costumes and be silly and be a silly face in front of this thing. No. You were for serious, all you could do is consume. And the site operator, remember that term, operator, is the one that is the thing that puts the content on the site. Now, back then there were some forums and some things. Fanfiction.net was becoming a big thing, right? So we were starting to dive a little bit into the interactivity, right? About around 1999, and it was when the interactivity started to go. We started to transition from Web 1.0 to Web 2.0. And that's when, the whole COPPA thing came into place, because you could fill out forms and you could give out information and you could put your fan fiction on this site that was hosted by fanfiction.net or netraptor.org or wherever you decided to put it. Netraptor.org, you'll have to look that one up. I'm old. LiveJournal. LiveJournal, the website that the Russians stole all your information and now know your biggest fears of all time and use it to scare you on Twitter. Remember LiveJournal? No one else does, but the Russians sure do. Ha ha ha! See, we're in the place that we're at for certain reasons. You got to know your internet history, folks. So this COPPA thing is why you would hear things like ask your parents' permission before signing on and all that stuff. So, what happened this time? What happened is a big thing. And that big thing is this. The COPPA compliance laws no longer just simply affect individuals who run websites, particularly for YouTube. The FTC has somewhat come into agreement with YouTube that YouTube content creators can be treated as operators. Now, if you remember that operator word, right? So I forgot exactly what order I put these things in, so I'm going to start clicking here. So here we go. So this is the big news. This is the thing that's changed. This is what's changed COPPA completely, basically overnight, and has gotten a lot of people worried. So let's read over this right now. So how does COPPA, and this is from the FTC site, link in the description below. It's a very useful link. It kind of goes over everything in sort of plain English and things like that. So, but I will read certain excerpts from it for you, because that's what you came here to do. You came here to become informed and let me read you the bedtime story. You don't want to read all this yourself. That'd be too much work. That's what my job is. So here we go. Let me read it. And of course, like, these glasses aren't actually glasses, they're just plastic, so I have to lift it up so I can actually read this. So how does COPPA apply to channel owners who upload their content to YouTube or any other third-party platformer? So this means, fanfiction.net writers, this applies to you too. Oh, and yeah, Twitch. Oh yeah, and TikTok. Oh yeah, and all those other sites that are Web 2.0. Anyone who uploads content is a site operator. COPPA applies in the same way that if... Okay. Before I go too much into this, I think... Hold on a second. Let's go over one thing first. So let's go over this part first, actually. Before we go over like how COPPA applies, or how COPPA applies to channel owners now, I'm going to back it up a little bit. I don't know why I put this out of order. I just remembered that I had this. So COPPA, the important thing to know about COPPA. The good news is that it really doesn't have anything to do with content directly. Or at least its original intention was not to do content. It was not about what kind of content they're watching. So this isn't like the fake Elsa thing, or like, oh, the fake Spider-Man thing, where it's like, oh, this looks like it's for children, but it's actually for adults. Haha, joke's on you, right? This isn't about ratings guidelines. That's more covered by the FCC than the FTC. The FTC cares about trading and trading of information and trading of products and information and things like that. So when they have the regulation of COPPA, or the privacy protection, it basically has to do with information of individuals under the age of 13. So if you recognize, so if you are a content creator on YouTube, if you go to your analytics page, they will tell you your demographics. And what you'll notice is that when you look at the age group, there is no information for anything under the age of 13. So basically, COPPA protects anybody under the age of 13 from information being gathered by YouTube without parents' permission. So how do you collect data? So there's two segments here. There's personal information and there's the collection thereof. So the collection, under COPPA, you are collecting information if you request, prompt, or encourage the submission of information, even if it's optional. And that's an important thing, even if it's an optional form, right? It's like, fill out this form. If you ask a underage person to fill out any form, you could be non-COPPA compliant. So I must say that I do not do many forms. The only form that I really do on my channel is those game voting things. So technically, those game voting, vote for the next stream games I do. If you are under the age of 13, I would be in violation of COPPA law, which is why if you are under the age of 13, first off, I guess nothing stops you from watching these things, but let me just give you a piece of advice. Don't ever fill out any forms or write anything or even put comments in the comment section. When I extend the thing to kick a comment in the comment section, it is not for anyone under the age of 13. And the reason being is this. Any information that you're giving out to me, now I'm a site operator. You understand this, right? So I'm a site operator now, right? We'll get into that a little later. But if I am a site operator, that means if I accept a comment from somebody who's under age of 13, my channel violated COPPA regulation. So if you are under the age of 12, you should not be doing that. And if you do that, and if somebody is evidence that somebody's under the age of 12 and they're submitting comments or even clicking like buttons or providing any information whatsoever, and you know that a channel is run by a person who's under the age of 12, you have to report it to Google, you have to report it or to their parents or both. Obviously, you might not have their parents' contact information, but basically that's what's going to end up happening, is that you have to make sure that if somebody is contacting, is using, interactive features on a website, on your channel, and they haven't gotten their parents' permission, you are now an individual operator. So you could fall under these guidelines. I'm not a lawyer, but I'm erring on you on the side of caution here. Because the FTC, as I noted earlier, has treated us all as operators. Now, this all sounds scary for a bit, but there is a silver lining. Because I found a loophole. But we got to go through everything first. You're gonna love the loophole, but you gotta work for it. Okay, of course I will. The loophole I found is probably gonna go viral. So you're probably gonna skip all this, and it's probably gonna be that. But trust me, you have to get the background first. And so let's go through the background first, and then we can have our desserts. Okay. All right. So here we go. Request, prompt, or encourage the submission of information. Information may be made publicly available, for example, with an open chat or posting function. So even like here's a thing. Even if it is like Telegram, a Telegram chat room, a Discord chat room, anything on the internet, an MIRC chat, okay, a muck, anything. If there is anything where a person is publicly posting information and that person is under the age of 12, you can get hit with a COPPA violation. If it is known that you didn't take action against the individual or, get them out of your chat room, right? The only thing that's allowed is if the channel is, is A, directed towards kids, or B, their parent has signed a permission form. And, even if it is made for kids, you have to have their parent's permission. In order for them to interact with those things, according to my understanding of it. Once again, I'm not a lawyer, but that's from my understanding of it, that's what it means. So it has nothing to do with the content itself. It has to do with whether or not kids are interacting and sharing data online. The thing that they get really interested in is if it seems to be child-directed information, or it seems to have child that it would lure children in more than anyone else, right? Because then they're going to look very closely to make sure that, children aren't sharing their information online, all right? Or that companies aren't gathering information about kids. We'll go over that a little bit more in a bit. So you say, with an open chat or posting function, unless you take reasonable measures to delete all or virtually all personal information before posting public, and delete all that information. So don't dox minors! You can get in trouble. Don't dox anyone. It's mean. I mean, I wish I had that protection. Honestly, I'm a bit jealous. I wish I was 12 again. No, I don't. No, I don't. I don't want to deal with primary school. That was a nightmare. Anyways, passively track a child online. So basically, using cookies or whatever. All right, so personal information. What is the personal information that you cannot collect? So each of these is considered. Obviously, they can, add or remove, but this is general gist. The full name, the home or other physical address, including street name, city or town, online contact information like email addresses, or any other identifier that permits someone to contact a person directly. For example, a IM identifier, a VoIP identifier, a video chat identifier. In other words, a screen name. Screen name, you're not even allowed, people who are under the age of 13 aren't even allowed to share screen names without their parents' permission. And so, it's very precarious. You cannot share IM information. You cannot disclose any of that. And you cannot collect any of that. Screen name or username, where the function is online contact information, telephone number, social security number. A persistent identifier that can be used to recognize a user over time and across different sites, including a cookie number, an IP address, a processor or serial device or unique identifier, a photo, video, or audio file containing a child's name or image or voice, geolocation information sufficient to identify a street name and or city or town, other information about the child and the parent or parent that is collected from the child and is combined with those identifiers. So in other words, if your child is online and you are identifying the parent through the child, that's even against COPPA violations. So if you think about it, and we'll go over this a little bit later, if you ever wondered why Nintendo, right? And I got to fix my collar a little bit because I'm running a bit long and it sometimes likes to come unstuffed. If you ever wondered why Nintendo has those long freaking alphanumeric character things for friends, for putting people on your friends list and stuff, that whole list that I just read is my guess. I'm not a lawyer and I don't know how the thing was developed, but my guess is that that is the reason, right? That is the reason why Nintendo has this long alphanumeric string to connect with anybody for their video games. Because that long alphanumeric string is not tied with any identifying information. It's not tied with your Nintendo account. It's not tied with your name, your address, your phone number. It's just a string of characters that you use to connect to other people's games. And because a lot of Nintendo's games are children-directed, right, they have to be more concerned about using screen names to share information with, like Xbox and every other gaming service does, right? It's like every other gaming service. It's like, hey, you have a profile, and that profile is identifying information, and you can share it with your friends, right? Or people can find you, right? Some people find me on Telegram without me giving it to them, and that's supposed to be a faux pas. I'm fine with it as long as people aren't harassing me with it. But if it's about somebody who's under the age of 12, that's a faux pas, right? That's a faux pas. Like my paws are faux pas, right? It's not a good thing. So that is what COPPA is. It is the collection, basically the laws that protect children from having information collected about them by site operators without their parents' direct consent. And like the law kind of goes over how the parent does give consent. It's not as simple as the parent going, okay, honey, you can go on that site now. It's literally like the parent has to be like, Google, I guess from what I heard, and I haven't tried this, but somebody else did, and they talked about it. Like Google, how they do it is if a child under the age of 12 wants to access like Google services and things like that, they have to log in and tie their account to a parent's account, and their parent has to give them permission on what they can use and how they can interact and all that other stuff. The parent has to go through the list of like, I allow my child to do this, 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 and this, right? And if the like, that's the whole thing, right? And whether or not they were complying with that, I don't know. Or whether or not some parents weren't doing it through the proper channels, and that's how Google got in trouble. MatPat indicated that Google got in real trouble because they were kind of bragging that they were a site that a lot of kids were watching, and it's like, well, how do you know that the kids are watching that site unless you're collecting information on them? Oops. Right? But it's like if the parents gave them permission to collect that information, then there's not really much that the government is supposed to be able to do about it. But that's a whole other can of worms, and I'm not a lawyer. That's a whole other thing. But we've described what COPPA is. What COPPA is not is, well, you said that was kid-friendly, and that's actually a rated G or PG-13 thing, sir. You just swore. You made an arse of yourself. You said arse several hundred times. That's not what the FTC can cover. That's not what COPPA covers. It doesn't cover ratings. But there can be some confusion, especially since the way that Google is trying to implement these things is saying that the video is for kids or it's not for kids, right? So when a person thinks of that, it's like, is my content for kids or is it not for kids? They don't think of like, is my content alluring to children to the point where the FTC might think that, I'm trying to lure in kids so that we can collect data on them, right? Those are the two things. Those are two different things, and it can be very precarious sometimes. It can be very hard to distinguish. Luckily for me, and let's talk about my channel for a little bit as an example. I went through and looked at the videos. I looked back over the videos that I did for this channel. I have already noted that I'm a news channel. So My content really isn't for kids. Like, kids don't really like the news. Yes, I'm wearing a fluffy animal costume with a spiffy orange tie, but it's some kids would be very scared of me. I've seen kids cry about fursuiters, so we scare some kids. Okay, we get mixed results when kids show up at the conventions. But mostly the people in the conventions are a mixed audience. There's adults, there's teenagers, sometimes parents bring their kids, sometimes those kids cry at our presence and stuff like that. So we are a mixed audience thing, and there is a mixed audience exception that a lot of people have noted that Google hasn't noted about these kind of things. So basically Google, once again, like computer scientists love their binaries. They love to put things in categories zeros or ones, and they go, there can't be more than two things. Are you crazy? You're crazy. There's not more than two things. It's like, okay, so it's for kids or it's not for kids, and like there's like mixed audience, right? Like for instance, Sesame Street for kids, The Muppets. Mixed audience. Team America World Police, adult, right? Those are the three options. Those are the three tiers. And of course, Google's like, Muppets? What are you, 6? 6-year-olds like the Muppets? Yeah, but it's a mixed audience. You're not gonna understand all the jokes if you're like 6. Yeah, sure. I mean, they're animals and they're Muppets and they're yeah. So like, yeah, of course, like, kids might find it interesting, but it's not made for them. It's made for the adults in the room. Oh, what are you saying? Adults in the room? Ho, 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 ho. Yeah, you're no adult. You're just a stupid idiot in a Roo costume. Oh, ho, 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 ho. Oh, ho, ho, ho. Yeah. So like, that's how I see it. Sesame Street, Muppets, Team America World Police. Those are the three like tiers, right? Kids, mixed audience, adult. But right now, all we have is Sesame Street and Team America World Police. America, every day. So it's like, what do you do? Well, I'm going to say not for kids, because kids don't care about news. And all this stuff is just going to go over their head anyway. It's probably going over most adults' heads. So, because I'm eccentric and weird and I don't take time to explain things sometimes, I try to make it as entertaining as possible. But I talk about some boring stuff. And when I look through my channel, there's a bunch of boring stuff. There's only one video that I am considering taking down. Because it's not really for kids, but it looks like it's like the thumbnail and the thing makes it look for like kids. Thankfully, I was lazy and I didn't make a lot of thumbnails, and all of them look very boring. I'm just sitting there with a thing next to me and going, hey, this is the topic. Whereas, like, what was it? There was the one video is Snagglepuss reviews Snagglepuss. It was when I talked in Snagglepuss, and I reviewed the DC comic that was about Snagglepuss. It was a review that I did in his voice. And it's certainly not for kids, because they had Snagglepuss say, "Spank my daddy." Spank my daddy? Heavens to Murgatroyd. Who would ever make Snagglepuss say, "Spank my daddy"? That is not right. It's uncultured. It is just, makes me feel, get this tongue out of my mouth, it's gross. So, it's not for kids, because the comic itself deals with mature themes. It deals with sexuality, it deals with government, it deals with all these adult topics. But if I were to just look at the frickin' title and go, well, look, you're reviewing Snagglepuss, and you're reviewing a comic about Snagglepuss in Snagglepuss's voice. I mean, you're trying to entice kids. Like, oh, no, because like I guess kids might read the DC comic. I think they'd find it quite boring. I found it quite boring, and I'm an adult. I already reviewed it, though, so if you want to watch the review, the clock's a-ticking. I might be taking that one down. So that's the only really big impact on my channel. But a lot of you might be concerned. It's like, because of this, right? Because now we are responsible, and we can be legally liable. So let's talk about that for a moment. So here we go. So how does COPPA apply to channel owners who upload content to YouTube or other third-party platforms? COPPA applies in the same way it would if the channel owner had their own website or app. So that means I own a website. It's called World in Review. I never saw myself as one, but now the government does, so thanks for that boost of confidence. But anyways, if a channel owner uploads content to a platform like YouTube, I'm going to do it in Snagglepuss's voice, what the heck. Make it entertaining. The channel might meet the definition of a website or online service covered by COPPA, depending on the nature of the content and the information collected. If the content is directed to children, and if the channel owner or someone on its behalf, for example, an ad network, collects personal information from viewers of that content, for example, through a persistent identifier that tracks a user to serve internet-based ads, the channel is covered by COPPA. Once COPPA applies, the operator must provide notice, obtain a verifiable parental consent, and meet COPPA's other requirements. For more information on how to comply with COPPA, visit the COPPA comply page. 6 things. So they use the word, and this is an important one. It's not highlighted. It's not saying. So once COPPA applies, the operator must provide notice. So basically what they're saying is, and this is going to be important later, is that we're operators. Channel owners are now operators. Now, of course, it talks about using ads, collecting personal information from viewers of that content. And I don't do any of that stuff, so basically I should be okay. And if you don't do any of that stuff, basically you should be okay. If you don't... And by the way, even in the comment section, it's like if somebody doesn't mention they are 12 directly or under the age of 13, if somebody doesn't mention that kind of stuff, you're good. Like, it's basically, as long as people don't know that the person is under the age of 12, that you're not getting information from a person that you know is under the age of 12, like, if a person under the age of 12 is watching your content, and it's not directed at them and they just happen to be watching it at the time, it's one of those sticky things, right? It's collecting data about them, but it shouldn't be, right? It really shouldn't be. And this is one of those things where it's like, I wish I could control everything and know that the person who's trying to comment is 12 and then block them from doing so. But I don't have that power. And unfortunately, like, I think that, and I think the whole thing is that the government, as for all of its flaws, should understand intent. And if your intent is to siphon information from people who are under the age of 12, and they will sniff you out and they will go, yeah, we're going to fine you. So, in speaking of the fines, we gotta talk about that part for a moment. So they did sort of walk it back a little bit. Everyone's been showing this whole $42,000 video. I could show the video, but you've probably seen it about 1 million times where the guys are like shooting fish in a barrel and we're going to charge you $42,000. So here they kind of walk it back a little bit. So what are the possible penalties for violating? And this is sort of the big thing. This is what's got everyone a little bit scared about this, because it's not just like, oh, demonetization or losing videos. It's literally like you're going to be charged some money. Some big chunk of change here. So here, let's talk about that. So the rule allows for civil penalties up to $42,530 per violation. That's more than anyone could ever win on a Jeopardy game. Isn't that right, Bucktown? But the FTC considers a number of factors in determining the appropriate amount, including a company's financial condition and the impact a penalty could have on its ability to stay in business. While Google and YouTube paid $170 million In another COPPA case settled this year, the operator paid a total civil penalty of $35,000. So, in other words, in a shorthand, if the FTC is going to go after channel operators, they're going to have to take a look at our finances, and they're going to have to say what is fair. $42,500 for a small channel like mine, who doesn't do this as a business, would be well over the, like, basically a cruel and unusual punishment. Because literally after taxes, like, I think that might be like a little over a year's salary for me. So basically, like, they'd be having me be a slave laborer for about a year. If they were to charge me something like a $42,000. And I think that's why a lot of furries were afraid, is because a lot of furries don't make that kind of cheddar, right? We don't make that kind of bread. Like, so having a $42,000 and then saying we're fish and they're gonna shoot us in a barrel. I mean, geez. Don't talk to animal people about shooting people with guns, man. That's just gross. That just makes people scared, man. Jeez, trying to hurt my ticker. All right. So if they do fine you, it probably won't be for $42,000. If there's anyone they're going to go after first, and it talks about how they're going to, they're kind of talking about COPPA and updating the legislation a little bit to try and make it more modernized, because as I said, it was written in 1999. So here's the most important part. And we're going to get into this bottom part, but let me go over some other stuff first, I guess. Actually, I can't even remember what I was going to go over. But, like, oh yeah, who they're going to go after first. So there are some major YouTube content creators who have kind of staved off the side of the law. So a lot of the biggest thing in the lawsuit, and the reason that Google had to settle, was because Google's marketing staff was kind of bragging a little bit that it's like, yeah, a lot of kids are watching our site, right? Well, kids are watching YouTube, and the regulators like, huh. So what the regulators did is that they found that there were some channels on YouTube that was like giving out advertisements and collecting data and running the full-on enchilada. On YouTube proper, that YouTube was bringing into its YouTube Kids site, right? So they had copies of these videos from YouTube and they put it into their YouTube Kids site because they wanted to have these videos to entice kids to go onto this platform that is much more stricter and more COPPA compliant and has it's a lot easier to regulate for them to make sure that they're within compliance. The problem is that there were a lot of channels that those channels that were moved to YouTube Kids also sort of remained on YouTube. And in the About page, they were saying, hey, we're the best channel for people under the age of 12. And then not only do you have a copy on YouTube, you have a copy on YouTube Kids. So basically they're saying this content is directed to people under the age of 12, and yet we have targeted ads and information gathering and, you know, collecting things based on a device, which is against the COPPA rules, as we mentioned earlier. So basically they would have to get their parents' consent for each of these things. And if they're treating site operators as channels, if they're treating each channel as a site operator as they are currently, then in essence, the parents can't even just give Google permission to do everything. They have to get permission from each and every single channel owner and go, hey, this channel can have my kids' information. This channel can have my kids' information. This channel can have my kids' information. This one can, and this one can, and this one can, but not you! Not you! So literally, by basically breaking up this and making us into a bunch of different states, now the parents have to treat each of us as different site operators. Joy, parents! Congratulations, hope you like filling out forms, because you're going to have to send my form to me. Don't let your kids watch my channel unless you send me an email or a mail or put a comment in the comment section. I don't know. How are you supposed to contact me? Right? Am I supposed to give out my email address and say, if you want your kid to watch my channel, please contact this and da da da. It's like, how are parents supposed to reach each and individual YouTube content creator under an operator status? This is not like the old days of the internet where you could just go like, oh yeah, that person runs this website. Where's the about address? Where's the contact information? Oh look, they have their street address. Isn't that so nice of them? Are you freaking crazy, FTC? No one puts their information like that out there anymore. How are the parents supposed to contact us to have their kids have permission to have I don't know. This is part of that whole debate that's going to be happening. But there's a great way to have this debate with the FTC and Google as content creators. Because as we noted, we're owners now. We are operators now. And under the rule of being an operator, you have the option of doing something really cool. And this is the thing that I've been building up to this whole time. And this is the part where everybody's going to be linking to my video at this particular timestamp, because this is the most crazy thing in the freaking world, and you're going to love it, and everyone's going to love it, and it's great. Because when Google went to the FTC and they worked out their little negotiation saying, hey, you pay us $170 million and you tell us how you're going to do this. And YouTube's like, you know what? We can't police every single freaking video site out there, so we need to make it so that every channel owner, we need to enforce it as every channel owner is their own site operator and that they can be held legally liable for these things. And the FTC is like, okay, fine, that sounds good to us. So now every channel owner is an operator. But little did Google know, when they did that and they pushed that law change into production without testing it, because laws are like programs, Google. You can't just freaking go, I'm going to update this code and push it to production without testing it to see if there's any code flaws that can blow up in my freaking face. Because you did. You did it, Google. You pushed that code out into production. You had the FTC push us as operators out into production without thinking of the consequences, not only to the FTC, but to yourselves. What the hell am I talking about? I'm talking about safe harbors! You stupid idiots! Oh! You're gonna love this, Google. We're operators now. Oh, wrong button. No! Wrong button. No! I'm leaving it in because I'm excited. Up here. Click on that. All right, click on that. Let's go back. All right, here we go. Where can channel owners go for more information? A look at the factors in COPPA rule will help most channel owners determine if their content is directed to children, which mine is not, thankfully. I feel bad for people who do like Lego and toy reviews. I really do. My heart goes out to them, guys. If you are still unsure about how COPPA applies to you, consider contacting an attorney or consulting with one of COPPA's safe harbor programs, which are self-regulatory groups that offer guidance on how operators can comply with the law. Visit the FTC's website for a list of current operating safe harbor organizations. By the way, the ESRB is one of those organizations, and that's probably the only ones most of you recognize. And as I noted earlier about the Nintendo thing, I think that the ESRB has like gone to Nintendo and said, listen, you guys, you need to use a different sort of way of connecting people online and other platforms because your games are very child-directed, right? And I think that the ESRB has to like take into consideration if a game is rated E10 or E, they have to consider those kind of things. And I think that's why the ESRB has become a safe harbor organization. They weren't originally designed that way. You know that they were originally designed for rating video games based on their content, whether they are appropriate for kids or not, rated E and T and M. But when COPPA came out, the ESRB signed up to be one of these safe harbor organizations, which help with COPPA compliance, probably within the video game industry. Because as I noticed, COPPA affects most internet it protects kids' internet's online interactions, whether that's by video game or by website or whatever. So it says it applies to you. Consider contacting the attorney or consulting a safe harbor program. For resources, visit your FCC childhood provinces. So I can one-up you better. I can do one better than just simply contacting an attorney or finding a safe harbor program. I have a better idea for YouTube, because how do you become a safe harbor program? Well, you have to be an operator. Guess what channel owners are now, Google? We're operators! That's right! That's right! Right here! Google, did you read this part? I don't think you read this part. I don't think FTC read this part either. Yeah, we have power now, guys. An operator will be deemed to be in compliance with requirements of this rule if the operator complies with self-regulatory guidelines issued by representatives of marketing or online industries or by other persons that, after notice or comment, are approved by the Commission. This is what safe harbors are. As an incentive for industry self-regulation and to ensure that protections afforded children under this proposed rule, with a capital R, are implemented in a manner that is taken into account industry-specific concerns and technological developments, like Web 2.0, for instance. Anyways, where was I? Technological developments. This section of the proposed rule with a capital R provides that an operator's compliance with commission-approved self-regulatory guidelines serves as a safe harbor in any enforcement action for violations of this rule. So if you're worried about the $42,000 in fines, get yourself a safe harbor. We're going to go over that a little bit. To receive safe harbor treatment, an operator, which we are now, we're operators, can comply with any commission-approved guidelines that meet all the criteria set forth in a prior section, which is all that kind of stuff we kind of talked about in general. The operator need not independently apply for approval. So that means you can come together, YouTube. You can create a group, a coalition, as it were. Don't call it a union, you'll scare Google. But you, as YouTube content creators, as the Internet Content Creator Coalition, or the IC3, right? Does this doesn't have a nice ring to it? Because here's the thing. We have 7 safe harbor organizations. None of them cover what we do. You have the ESRB, you have like TrustE, you have like Kids Safe, you have like these other organizations whose intent is not about internet content creation, who don't cover what we do. So we need to come together and get a lawyer, okay? We need to follow what Google told us to do and get a lawyer, but not as individuals, not as individual content creators, but as a concerned coalition of internet content creators that are worried about the platforms that we are running on not following and doing their part to protect the privacy of children online. We, the internet content creators, the operators, thusly form a group of individuals called the Internet Content Creator Coalition, whose sole duty is to work with the FTC to ensure that Amazon, that Google, that all these companies are complying with the rule of law when it comes to COPPA. Because we're not going to wait on the algorithm to do it for you, YouTube. It's time for the human touch. A human touch that you, by the way, have opened the door to. You have opened the door for content creators to come together to form a legally protected group called a safe harbor under the COPPA law because you wanted to throw us under the bus. Well, guess what, buddy? Kangaroos got claws. And if you try to run them over with a bus, you're going to have some flat tires. You like that? Charge me $42,000. I'll create a group to protect my ass from that kind of fine. And now so will other YouTubers. You made your mistake. All we need to do is comply with those particular things as an organization. And there's a little bit of a stipulation to it too. Things such as, following the rules and regulations of it. And also, you can also give voluntary payments to the United States Treasury in connection with an industry-directed program for violators of the guidelines. So, if our little bit of internet content creators coalition, decides that, we don't want to be charged $42,000, so it might be in our best interest to, maybe take a piece of our pay, maybe like $1,000 a year of our YouTube money and give it to the United States Treasury to help fund COPPA compliance organizations. We could do that independently. And yeah, you could try to take down our YouTube channels, but I think that that's going to bring its own kind of lawsuits. Don't you? That you're saying, well, you're not taking this COPPA thing seriously now, are you? Because you're going after people who are trying to work with the FTC to fix the problems that you created as a site. And that we're going to make sure that you don't make that same mistake again. And try to throw us under the bus by giving us no option for mixed content. Yeah, you brought this on yourselves. You guys are tech nerds, right? I'm a computer science graduate too. I grew up with a frickin' bachelor's at a state university in New York. And I just pawned a whole bunch of you idiots who just frickin' did this thing without even thinking about the consequences of it. Now the consequences are here. Right there. In this law. You made us operators. You made content creators operators. In order to try and save yourselves money. But guess what? Kind of blew up in your face. Because now the content creators are going to be an organization. And by the way, I'm not going to be part of this. I'm just saying that this is the direction that people should go. And because I think it's time for YouTube to start acting as a community. It's time to start rising up against this algorithm. We're not going to wait for the computer to fix this problem. We're going to fix this problem. As the operator power that has been invested in us by the settlement between the FTC and Google, through the power vested in that, we're going to become a safe harbor. We as YouTube content creators are going to become a safe harbor organization. We're going to create a safe harbor organization. We're going to follow the rules of COPPA, and we're going to ensure that any platform that we that we create content for, whether it be Twitch, whether it be Google, whether it be anyone, is following and complying and not risking our careers because they can't be compliant with the FTC. We will work with them to make sure that that is the case. But we will also make sure to operate under our rights to become a safe harbor organization to protect ourselves from $42,000 fines. Even if we have to give a little cheddar to the Treasury to do it. Better $1,000 a year than a $42,000 violation, am I right? Well, or, if you have enough people in this coalition, have like a $20 yearly membership for the people who are part of that organization. And all that money goes to the Treasury for this particular instance. Make it a safe harbor organization. Now, don't see it as a revenge thing. I'm kind of playing it up that way because a lot of people are upset. But it has to be also, an organization which does care about COPPA compliance and moves forward with it. Because if you use it as a way to just protect yourself from legal liability and you're still like running afoul of the law anyway, the FTC is just going to rip it up and toss it. As I said, I'm not a lawyer. But I can read legalese a little bit. And you should get a lawyer if you plan on doing this. If you want to share this with higher content creators, I'm all for it. I'm pointing the way. Other people have to take the ball and run with it. Content creators such as Markiplier and Jacksepticeye and Game Grumps and the Completionist and yeah, maybe even PewDiePie. Maybe, I don't know. But, they should come together as an organization. And because YouTube is their passion, YouTube is their career. I do this as a side hobby. If my channel goes tomorrow, it's one thing. I still fall under the rules as a site operator, so I technically could apply. But I don't have time, really. I run a furry news site. I talk about furry news. That's the thing that I focus on. And I also focus on my career, which is a job that helps to keep the lights on, which if the lights don't stay on, there ain't no YouTube, there ain't no Google, none of y'all exist. And so I think that I do good at what I do, and I would rather stay in the field that I'm in at the time. I'm where I'm needed. And I think that there are other people out there who are YouTube lawyers. I think I can think of a few off the top of my head who might be very interested in this particular topic, and whether or not this Internet Content Creator Coalition as a safe harbor for COPPA compliance is an option for YouTube creators. It'll give them the opportunity to come together once and for all against YouTube's algorithms and trying to divide and conquer YouTube content creators. It'll allow them to be an independent organization that can talk about the concerns to the FTC, but also try to help other content creators comply with those FTC things, to take the role that Google refuses to take. As a safe harbor organization, the FTC will do what it can to teach your organization how these content, what they look for when it comes to compliance issues. And you can make workshops that will teach people how to do these kind of things. That is what safe harbor organizations do. Unfortunately for us, the current safe harbor organizations that do exist don't really apply to what we do. They don't really understand what we do. The FTC doesn't really understand what we do. So it's important that we open that bridge of communication. The IC3 is intended to do that, or whatever you want to call it. Honestly, if you don't like the IC3 or the Internet Content Creator Coalition, if you don't like that name, come up with another name. Do whatever you want. It's your baby now. I gave you the rules that you can use to apply to it and find out about it and try to pursue it. But it's up to you. To you who have YouTube as a passion, to you who see YouTube as a future of sharing content and sharing information with one another. And Google, I apologize for shouting earlier. I get a bit sassy about things, but you done messed up. You done messed up hard. I don't think you intended for your content creators to actually form a group, but you kind of opened the door for them to do so through your settlement, because we're operators now, and operators can create safe harbors and can organize as safe harbors. And there ain't nothing you can do to touch them. Because if you do, I think the FTC will know where your loyalties lie. Whoopsies. Anyways, thank you very much for watching. If you're new here, be sure to kick that like, kick the subscribe button, and ring that bell. Kick a comment in the comment section. But obviously, if you're under the age of 13, don't do any of that because it's not legal. Don't do it. Do it when you're, well, you could come back and do it when you're older. Okay? Anyways, thank you very much for watching. I'm going to get the hop out of here. Oh yeah, by the way, one more thing. The reason you need to get a lawyer when forming this group is because you need to know the nuances of applying to become a safe harbor organization. Because they really like, they are very particular of the way that they would like to expedite that application to be a safe harbor organization. You're going to love this. To enable prompt review and accessibility to the public, the request and supporting materials should be submitted, if possible, in electronic form on either 1/51/4 or 1/31/2 inch computer disk with a label stating the name of the person filing the request and the name and version of the word processing program. Programs based on DOS or Windows are preferred. Files from the operating system should be submitted in ASCII text format. So if you're running on an Apple's OS, you better submit that thing via ASCII, huh? Where are you going to get a frickin' floppy disk, though? Man, you know, it's like if some of you guys are going to comment, it's like, why should we give the Treasury money? I mean, clearly they're just looking for money. I mean, why? I'll just take the risk of trying to get the $42,000 fine. Please, I mean, they need it. I mean, they're still using DOS computers. By the way, I'm being facetious. This law was written in 1999. Isn't it so antiquated when the law is so self-aware enough to go, well, we want the industry to self-regulate because we don't know where technology is going in the future, and how are we supposed to know where it's going in the future? And then they're like, in the safe harbor section, they're like, well, if you could kindly please get a floppy disk and copy your resume to be or your application to be one of these organizations, and send it to us via this disk, right? It's like, it's so cute. It's so cute. Right now, it's like, I don't think that you need to do that. That's why you need a lawyer. You need to know how to actually contact these people. I don't think you use a floppy disk now. I don't think that's how they intended it. But anyways, once again, thank you very much for watching. I hope that this was entertaining, that you learned a little something. As a disclaimer, and to cover my arse, I'm not a lawyer. I'm a computer science major who does data entry and project coordination. I can read legalese a little bit, and I'm surprised that no other lawyer has really brought up the idea of the safe harbor. It'll give them something to talk about, and probably some people with more expertise. And I think particularly some of the lawyers who are really interested in this whole COPPA thing, I think will be really interested if they can make a career out of creating a coalition of a group of people whose very goal and purpose is to ensure that our modern infrastructure is adhering to COPPA rules and regulations on behalf of content creators, especially to you YouTube lawyers. I think that'll be, if some of you lawyers are like, oh, this is very interesting to me, it could be a full-time job for you guys. I opened the way. That's all up to you now. You can thank me later. Anyways, I'm going to get the hop out of here. Thank you very much for watching. See you later.